Welcome. My name is Shannon Bryant. I'm the Traffic Safety Resource Prosecutor for the state of Nevada. This is part of the TSRP training video series intended for Nevada law enforcement conducting DUI traffic stops. These short training videos are intended to refresh training for in-service officers who have already completed their Category 1 training. This video briefly covers DUI blood draw warrants, when to get them, why we get them, and covers a common misconception about juvenile DUI suspects. So, without further ado, let's get started. Our state law, specifically NRS 484C.160, covers evidentiary testing. Subsection 9 is the section we need to look at because that covers when to get a warrant. That section says, if the person to be tested fails to submit to a required test as requested by a police officer pursuant to this section, and the officer has reasonable grounds to believe that the person was A, driving or in actual physical control of a vehicle while under the influence of an intoxicating liquor or controlled substance, or with a prohibited substance in his or her blood or urine, or B, engaging in any other conduct prohibited by NRS 484C.110, 484C.120, 484C.130, or 484C.430, then the officer may apply for a warrant or a court order directing that reasonable force be used to the extent necessary to obtain samples of blood from the person tested. Thus, we have a couple of prerequisites here, preconditions that must be present before we get the warrant. First, we must have a failure to submit to the test. This does not have to be a refusal. It could also be a failure to make a choice, an inability to make a choice, possibly due to intoxication or even a language barrier or some kind of disability. And we must have reasonable grounds. Specifically, we need to meet probable cause here because we're dealing with getting a search warrant to go inside a person's body and conduct a search for evidence. Probable cause is going to be the minimum we need to get this warrant. So why do we need probable cause? Well, as I just hinted, this is an invasive search. You're asking for authority to potentially use force on a person to puncture their arm and pull out blood for testing. Not surprisingly, our United States Supreme Court has held that this is an invasive search. Further, just because that evidence is dissipating every minute as the person is sitting there in front of you does not justify a warrantless search. The U.S. Supreme Court in the McNeely case changed the way we do things here in Nevada in 2013 because we used to have a section in NRS 484C.160 that specifically said no warrant was needed because the driver already consented to the search just by driving on Nevada's roadways. That concept is called implied consent. The idea is that a driver impliedly consents to the evidentiary testing when he or she drives on Nevada's roadways. While this is true in concept and is enough to revoke a person's driver's license if they refuse testing, in a criminal prosecution it is not enough. We need a warrant. Probable cause that our suspected impaired driver has committed a DUI must be present before we can get that warrant. So what about consent? Can't a person consent to the blood draw? Yes, of course. A person can consent to a search, and the DUI blood draw is a search. However, it is important to understand some basic tenets of our constitutional rights under the Fourth Amendment. First, any search conducted by the government without a warrant is presumptively unreasonable. That's our starting point. That's the default position. No warrant equals an unconstitutional search. But there are some exceptions the U.S. Supreme Court has carved out over the past 200 plus years. Exigency is one. This might be in the case of a fresh pursuit of a suspect into a home, or if someone was crying out for help inside of a residence that would justify an emergency forcible entry. Plain view is another exception. Any search incident to arrest also does not need a warrant. Searches of automobiles, in some instances, although not all, will not require a warrant due to their inherent mobility. Special situations like schools, border crossings, probationers, and parolees, those have been recognized as situations where a search warrant is not required. And last but not least, consent. The burden for any of these exceptions is on the law enforcement officer to demonstrate in his or her report and later testimony that the facts fell within one of these exceptions and that a warrant was not required. And for consent, it will be up to the law enforcement officer and the prosecutor as well to show that the consent was freely and voluntarily given. That is, this person freely and voluntarily waived his or her constitutional right and submitted to the search. For that consent to be valid, the person must understand what he or she is consenting to. As you might imagine, this can become a challenge in an impaired driving case because, by definition, the law enforcement officer believes this person is impaired. How much impairment is too much? At that point, the person might be too impaired to understand the consequences of his or her consent. Language barriers are also a problem because, of course, the suspect may not fully understand what the law enforcement officer is presenting to them in terms of a choice. Age could also be a consideration, as could cultural considerations. For example, if the person has only had limited experience in the United States, he or she might not fully understand that they have a right to say no, because such a concept is non-existent in their home country. The bottom line here is that consent is an exception to the warrant requirement. Because we, meaning the prosecutor and the law enforcement officer, have to prove the consent was freely and voluntarily given in every case, it really does not make our case easier to prove. In reality, it can make it much harder. Now let's cover a common misconception. What happens when we have a person under the age of 18 who is also suspected of committing a DUI? Contrary to what some may think, including a few justices of the peace here in northern Nevada, the warrant process for a blood draw is basically the same for all drivers, irrespective of age. NRS 179.045 covers the search warrant and seizure order process. This statute expressly states that these orders are issued by any magistrate judge in the state. That includes any justice of the peace or district court judge. There is no special application process or juvenile court procedure for drivers under the age of 18, and we do have quite a few of them. In fact, our operating statute for evidentiary draws, NRS 484C.160, already takes into account minor drivers. This section instructs officers what their obligation is. It reads, if a person who is less than 18 years of age is requested to submit to an evidentiary test pursuant to this section, the officer shall, before testing the person, make a reasonable attempt to notify the parent, guardian, or custodian of the person if known. Therefore, when you have a minor who is a DUI suspect, the law enforcement officer's additional obligation for the blood draw warrant is only to make an attempt to notify that minor's parent or guardian before the blood draw occurs. Otherwise, the entire warrant application process is the same. A special note here, if the law enforcement officer does make contact with the parent or guardian, the officer's only obligation is to inform them of the arrest and the evidentiary testing that is about to take place. The officer should also tell the parent or guardian where the minor will be taken afterward so that they can make arrangements with that facility. the parent or guardian has no right to delay the evidentiary draw and no right to be present for the draw. So, should the parent or guardian attempt to tell the law enforcement officer to wait or not conduct the test, the law enforcement officer must not comply, as that would be a violation of his or her own legal obligations and departmental policies. The best practice would be just to politely inform the parent or guardian that any delay is not possible, and then to reiterate where they can go pick up the minor after custody has been transferred to the appropriate juvenile facility. Also, while there may be justices of the peace who believe differently about this process, there is literally no statutory authority or case law to support a different process from that which is described here. Indeed, after discussing this issue with other traffic safety resource prosecutors across the country, I can say with confidence that there is no special juvenile warrant process or no juvenile judge requirement anywhere for DUI blood draws from minor drivers. That said, it is best practice not to argue with a justice of the peace. If they are insistent, they do not have jurisdiction to determine the warrant, even though they actually do, the law enforcement officer may simply be stuck with an under the influence DUI without blood evidence. Make sure to document everything in your report, including all observations of impairment as well as your interactions with the judge. Let's recap what we covered. DUI blood draws are constitutional searches pursuant to the Fourth Amendment. Under the Fourth Amendment, warrants are typically required for any search conducted by any governmental agency. Consent is a well-recognized exception to the warrant requirement, but you must use caution here because the burden is on us to prove that the consent was freely and voluntarily given. Lastly, minor DUI suspects are subject to the same legal process for blood draws as adult drivers, with one small exception that the law enforcement officer must attempt to notify the parent or guardian before the blood draw takes place. This concludes this training video. I'm Shannon Bryant, your Nevada Traffic Safety Resource Prosecutor. On behalf of the National Highway Traffic Safety Administration, Nevada's Office of Traffic Safety, and the Washoe County District Attorney's Office, thank you for all you do and for keeping Nevada's roadways safe.